Liborous Oshomah joins us on the Kogi matter. He's also a lawyer. Good morning and thanks for joining us.
Good morning.
You had Chris Akiri telling us more on Section 33 on this particular matter. He did say the talk about having a logjam, constitutional logjam on this Kogi issue, shouldn't arise in the first place because we have to go back to Section 33. And I'm quite sure you agree with him.
No. I can't agree with such a isolated interpretation of our laws. And that's why even the courts had consistently held that in reading our laws, you must not read them in isolation. That's, you read them holistically. You don't take out one section and hammer on that section and exclude all other sections. Section 33 talks about substitution. It gives you a right. It invokes a right. Section 36 places a time on that right. Otherwise, the Nigerians wouldn't have been quarreling. Lawyers wouldn't have been arguing. We all would have just said, look, that is the position of the law. And so, I was happy Newton read Section 36. And he said he find a way of wriggling out of it to say, look, that does not. It puts a time on that debt that you're talking about. That is why even the court had heard that you cannot substitute candidates, Because even if you do that, let's assume that that is the intendment of the lawmaker, to allow substitution even in the middle of the game. You create a major problem. Because a situation where you have candidates, an election is in process, once the opponent discover that this candidate is leading, like we saw in Niger Delta, what gave rise to kidnapping and crisis, you can just go, eliminate the candidate so that, the candidate will be substituted. That is not the intendment of the law. And that is why Section 36 now puts a time limit that if the candidate dies before. And so there is no court that will read that section in isolation. No court in this land that will read that section in isolation. They will have to read it with alongside other sections, especially Section 36 that talks about the time of death.
I just want to clarify this. So you're saying is one can't just come up and take a portion of the Constitution or any of the laws that is so clear and run with it.
If that section...
What you're saying is that the Attorney General was wrong because that was what he quoted in that video.
You see, that's one of the problem that we have here. That's why some of us are consistently demand that there should be a divorce between the office of the Attorney General and the Minister for Justice or Commissioner for Justice, as the case may be. Because if you have an Attorney General who is the chief law officer of the state who is not partisan, who is not appointed by the president, he acts, his interest will be the total interest, the interest of the entire country, and not to protect the interest of his party. But what you have here is a situation where one man nominated by the president and his party is in crisis here would want to give a legal opinion, to favor his political party. And that's why I will fault that opinion given by the Attorney General. Because you cannot read Section 33 in isolation. It is not done. You must read it, in consideration of Section 36, that if a candidate dies before the election, that is the timeline for that. When it happened, why were we all shouting that the law did not make provision for such a scenario?
It can also mean that lawyers were shouting because they had not seen that 33.
Because they had read 33 and read 36 together.
So what about the clause that is there, the except?
Except in the event of death. And like I told you, Section 36 now put a time.
But it ends there. This is Section 33. It clearly states a political party shall not be allowed to change or substitute its candidate whose name has been submitted pursuant to Section 32 of this Act, except in the case of death or withdrawal of the candidate, and there's a full stop there.
If you look at that if you look at, that's part 4 of the Electoral Act. It starts from section 25, all up to section, section 77. And then part 5 talks about political parties. And so in reading that section 33, you cannot just read it in isolation. That's what I'm telling you, that it's section 33 ends there. You now move to section 36(1). It says, after the time, if after the time for delivering of nomination paper and before the commencement of the poll, a nominated candidate dies. That is the death that section 33 is talking about. The Chief Electoral National Commissioner for the Resident Electoral Commissioner or the Resident Electoral Commissioner shall, being satisfied of the fact of the death, countermand the polling which the deceased candidate was to participate, and the Commission shall appoint some other time convenient for the election within 14 days. In this case, the Commission, the Electoral Act, if you take 33 in isolation, you say a candidate dies. There is no provision in this law for the time to conduct the election.
You know what I see here?
And so that is why the substitution is not at the time of conducting election before result have been, before a winner had been declared.
You see, if you look at 33, it looks as if it's looking at the before, during, and after here, talking about political parties shall not be allowed, a moment here, so that you can explain, especially on this, to change or substitute except in the case of death or withdrawal. So withdrawal, now we're looking at maybe a process is happening, or even the case of death. Coming to 36, they're telling you about the action that the electoral officer can take in the case of what has happened in 33.
And
so then you can countermand, you can stop, place a hold and seize, and that is what is happening now. It looks as if... Let me just land. It looks as if you and Mr. Kiri are both on the same page on this.
No, we are not on the same page. Mr. Kiri is saying that you can substitute, even at as we are now, even at the point of announcing a winner, once the candidate dies, that you can substitute at any time. That is what he's saying. And I am saying that the law, section 36, places a limit on the time for substituting. If the lawmakers wanted the substitution to be, to be invoked at any time, there wouldn't have been need for section 36 of the Electoral Act. They would have just written section 33 and left it there. Maybe section 36 would have been any other thing. But once you have section 33, talks about death, you now have section 36, giving you a time limit. It gives you a time limit. You cannot now
time limit for what will happen with section 33.
And that time limit is before the election, not after the election. That time limit is before the election.
If after the time of delivery of nomination paper, that's a before there, and before the commencement of the poll, right? Yes. A nominated candidate dies. The Chief National Electoral Commission is quite clear.
Before the commencement of polls.
This is before commencement of polls.
Yes.
But for 33, it's not telling you what can happen.
33 comes before 36. 33 says in the event that a candidate dies. 36 goes further to explain, because you cannot explain, since they decided not to explain everything in 33, you now go down after 33 to say the man dies before commencement.
Okay, at this juncture, if you are of the opinion that substitution is wrong, what should have been the option?
Newton will bear me witness. I stated here the last time that during every election, what INEC owes us a duty, first and foremost, to tell us these are the numbers of registered voters. These are the numbers of those people that will be allowed to vote. The number of those people that have collected their permanent voters card. Because INEC's regulation is if you don't have, there's a new device for voting. And if you don't have your permanent voter's card, you cannot vote. You will not be allowed to vote, because we will use a device for accrediting voters. And so without that card, we will not allow you. And so what happened in all other states' elections, including the ones that were staggered,